My name is Nikolai Chekasov. I am treasurer of the Midlands IChemE group, and I'm also managing director of a small company, USefulness. We are making flow chemistry. And I asked Nonny today to join us and to talk about intellectual property. Nonny worked for some major pharma companies, so he knows a lot about chemicals industry. He also helps studies, so I know him personally for quite a few years. He did some patents for us, so cannot recommend him sufficiently enough. So Nonny will be talking about general introduction of intellectual property for chemical engineers. We try to run this session interactive, so if you have some questions, if you can type them into the chat box, but if possible, we will try to ask you to ask your question in person, so it's more like a queue than anything else. And we also will record this event, so please be aware. Thanks a lot. Yes, Nonny, let's start.
Thank you very much, Nikolai. That was an extremely kind introduction, and thank you to the other organisers as well for helping arrange this, and of course to you all for giving up some of your valuable lunch break to hear about intellectual property. I am conscious that intellectual property is not the most kind of exciting of topics sometimes, so I'm going to try and keep it as kind of interesting and useful as I can for you. I'm going to give a bit of a general introduction about what intellectual property is, and I'm going to talk very briefly about what the different the major different types are. But then I'm going to focus on inventions and the type of IP that protect them, which I call patents, because inventions and patents are kind of the most important form of IP that you'll run into on a day-to-day basis as chemical engineers, I think. I'm then going to talk about what makes an invention patentable. As a segue into some practical IP tips, and this is really what I want to get onto, because at the end of this presentation, I don't expect everyone to come out and suddenly be a fully trained patent attorney that knows everything about the law. But if I can give you some tips that allow you to see when you might have inventions, when you might have patentable inventions, the kind of things you should think about with IP in the background while you're doing your day-to-day job, then I think that's the main aim here. So, and then we'll finish off, as Nikolai said, with some questions. So, first of all, what is intellectual property? What is IP? I mean, really broadly, it can be defined as the products of human imagination and creativity, and there are all kinds of subcategories of that. Of course, you have things like books, music, artistic works. You have design, so architecture, clothes, designs, those kind of things. The kind of things that you see in commerce, like trademarks. For kind of differentiating between different people's products and services, and you have inventions, which I'll come on to in a bit more detail in a moment. Now, all of those things, kind of the products of human imagination and creativity, are obviously very valuable to society. And so, in the way that society does, it tries to encourage them by putting in various legal rights systems that protect them. And the reason that these legal rights systems exist is that it's quite hard to create something, but it's very often easy to copy it. And when somebody has put a lot of effort into a creation, it's appropriate, in society's view, it's appropriate that they can get some protection for it. Sometimes it's time limited, but for a certain amount of time, they're rewarded for their creativity and for having made the effort to the betterment of society. That sounds very high-minded, but it's quite an interesting thing to always have at the back of your mind when we talk about IP, and I'll touch on it a few times in the talk. So what legal rights systems do we have then? There are various ones. I've listed a few, the most important here. You've got trade secrets, which protect commercially valuable confidential information. So a good example of that would be something like the Coca-Cola recipe, which is kept in a safe at the top of a tall building in Manhattan that only 3 people have got access to. Because it's incredibly valuable. Nobody else can make Coca-Cola easily because they don't know what the recipe is, and it's very hard to reverse engineer. So keeping it as a secret is actually very smart, and it's as long as they can keep it a secret, they'll get the value out of it. Copyright protects literary and artistic works, so some of the things I already mentioned there, like books, music, those kind of things. But you will run into it as scientists as well. You kind of, when you submit journal articles, you're asked to sign over your copyright, so your right to stop other people from copying your journal article. You sign it over to the publisher so that they can, they've got the right to distribute and copy it. So So even for scientists, copyright is occasionally important. You've got designs, which are a type of IP that protects visual appearance. A good example of a sort of a registered design would be the design of your phone. So when Apple brought out the original iPhone, they actually registered the kind of black oblong with a few buttons on it design, and it was extremely powerful because all the other phones wanted to use that design as well. So that registered design enabled Apple to stop all kinds of imports, and you might have seen it in the news or even seen that your phone was delayed from market because of these kind of design rights being asserted against between mobile manufacturers. Trademarks we all use on a daily basis. So they're the things you use when you go to the shop and you want to buy a particular product. That's how you identify them. They're extremely important and underlooked in value. I mean, well, maybe not underlooked in value, but it's obvious that the Coca-Cola brand or the Pepsi brand are very important and worth a lot of money. And brand owners are try and make sure that people don't denigrate their brands or use them in sort of parodies and things that make them lose values because they're probably the most valuable type of IP, I imagine, in the commercial world. And then finally, we've got patents that protect inventions, and I'm going to spend a couple more slides talking about those. So first of all, what is an invention? Now, despite the fact that inventions are very important to society and legal systems to protect them are in existence, the patent system I'm going to talk about, they're actually not very well defined. So that a general definition might be something that's never been made before, or the process of creating something that's never been made before. But that would cover all kinds of IP that I've already mentioned, like designs, copyright. And when it comes down to it, the legal systems find inventions so hard to define that they don't actually do it. So if you go to the UK Patents Act or any of the other legal systems that try and protect inventions, they don't often actually positively define what it is. They just say often what it isn't and what it must be to be patentable. But I think a good way to think of them it's more than an idea. It's something that's it's an idea that's been made or reduced to practice and be shown that it's useful. And because that's a bit of a mouthful, one good way of thinking of an invention is a solution for a technical problem. So if you have a technical problem to fix, you have, for the sake of argument, chemical engineers, you have a piece of apparatus that you want to fix so it's more efficient and cheaper to use, and you find a solution that does that, you have made an invention. So you guys will be making, I mean, your job is basically to solve inventions, and you'll be making them on a daily basis. So every time you solve a technical problem, particularly in a way that isn't, that works and isn't, it wasn't obvious, you didn't just go to a paper and apply a solution that somebody's already talked about, then you might be talking about inventions, and you might even be talking about patentable inventions. So it's good to be aware of what that definition is. So what's a patent then? So an invention's solution to a technical problem. You've made one. How do you protect it? You've made a new drug. It would cost you billions to develop it, but now a generic company can come along and just make it very easily. How do you protect it? Well, you file a patent. And a patent is a legal right that's granted by a given state that allows its owner to exclude other people from basically commercially exploiting an invention. It covers for a limited period of time. Although patents are exclusive rights, so as I've said, you can use them to stop people from competing with you, they do not automatically allow you as a patent owner to practice your invention yourself. That might sound a little bit counterintuitive, and people think, oh, I've got a patent, now I can go and sell my thing. But actually, you must be careful, because it's possible that other people's patents that have already been granted might already cover your product more broadly. Your little product is a very specific example, but they have a broad patent that covers all products in that class, for example. So it's not a guarantee that you can go out and sell freely. It's just a guarantee that you can stop other people from selling your invention. And it's an extremely powerful tool. It's one of the most powerful forms of IP. Stopping people from launching competitors can be worth millions or even billions. I've worked on a lot of drug patents, which are commonly worth, drugs sell 5 billion a year. So if you've got 20 years of 5 billion, you can see how much a patent can be worth. It makes my job quite stressful, because you're obviously dealing with very expensive things. But because it's such a great prize, there are very significant restrictions put on who can get a patent. And it's only granted to the first applicant to fully disclose the invention they're trying to cover, and that's called the patent bargain. And if you think about it, if you go back to what I said about on one of the first slides about society and IP and what it's trying to do with these legal rights to protect IP, what society's saying is, if you come along with an invention and you promise to me that you will disclose it in a published patent application, because that's what happens when you file a patent, it will get published, so that society can see what you've done and they can potentially build it, and then in 20 years they can freely use it, I will give you this massive monopoly for a period of time. And that patent bargain informs everything that I'm going to tell you next, everything about the law and how it works. If you understand the patent bargain, you will understand why the law is written like it is. And the first way it manifests is that not every invention that somebody makes will be worthy of a patent. It won't be patentable. And there are many legal criteria that are kind of put on an invention to say, it must meet these criteria in order to be patentable, because again, society is trying to say, if I'm going to give you this monopoly that's going to chill other people from their economic activity, you've got to make it worth my while. So what they say are, among other things, that your invention must be useful, they must be novel, and they must be inventive. These are terms you might have heard if you worked with patents before, and I'll touch on them in a bit more detail now. But there are other kind of criteria, exclusive criteria that apply to inventions before they can be patentable. And these are, again, they're designed to help society. So you can't patent an artistic work. It has to be a technical solution. So the reason for that is we've already got copyright, and they don't want to stack monopolies that stop people doing things on top of each other. You can't patent an abstract or mathematical idea, like a theorem or something like that, because these are so fundamental to mankind's ability to develop that they can't be restricted, so you can't patent them. So even though they might have, you might be technical solutions that involve kind of these kind of fundamental ideas, the patent system doesn't let you protect them, because it would be too much. It would be too much of a cost to society, if you like. And you can't patent things that are contrary to public policy or morality. Two good examples of those in working memory are sort of certain munitions, like cluster bombs, are often excluded. Things that are inherently society doesn't think they're moral, and things like experimenting on sort of viable human embryos, that kind of thing. So patent law is all set up to make sure that they don't give patents away willy-nilly, because they're bad economically otherwise. Now let's talk about usefulness. So this is actually a very low bar in practice. So usefulness is actually defined in most of the legal systems as it can be made or used in any form of industry. So this particular, I'm showing a picture here, and you're wondering what on earth I'm showing. I'm showing a picture of an invention here. This is for keeping dogs' ears out of food while they eat, and you can see if you have this particular dog, although he doesn't look very happy about it, I'm sure you might want to keep his ears clean. Can that be made or used in any kind of industry? Yeah, it can. There will be a market for these kind of things, believe it or not. And this actually is a picture from a granted patent that was given back in 1980. So in practice, what the usefulness requirement is trying to do is saying, I'm not going to give it to you for something that's not a technical solution. It's not of the sort of character of an invention that you've thrown to work. It's more than an idea. You've solved something, and it has to be useful. But it's a very low bar in practice. The only time it ever becomes relevant is, I don't know if anybody can take one look at this and wonder what it is, but it's actually a perpetual motion machine, which of course can't be made or sold or whatever in any kind of industry, because it's not possible. So these are the only kind of things that tend to be rejected for usefulness. And patent attorneys over the years have seen it as a hobby to try and get these kind of patents granted as a joke, which tells you a lot about patent attorneys and their senses of humor, I think. A more important restriction on what can be patented is novelty. So to be patentable, an invention must be novel. It can't have been previously disclosed to the public. So again, the patent bargain's there. It's saying, if society already knows about your solution, I'm not going to give you a patent for it. We've already got it. Thanks for your effort. Sorry. And it does happen that people make inventions that look great and they look like they solve a problem, but actually it turns out that 20 years ago somebody also thought of it, and maybe it wasn't even important there, but they've made it, they disclosed it, society's already got it, and now you're not having a patent on it. one thing that people struggle with sometimes about novelty is that a disclosure can be by any means and can be anywhere. So you could tell somebody in the corridor of a public building and think, nobody actually heard me. I was just talking to somebody, and or talking to 3 people that had come up to me and they were chatting away, and I told them about it. That might be considered a public disclosure. Whether there was an air of confidentiality over it, maybe that might stop it. We'll come to that later on. But you've got to be very careful about how you disclose things. Again, I'm sort of hinting at the practical tips, but when you have done something good and you solved a technical problem and have an invention, you often want to talk about it, and you often publish it in a journal article. If you do that before you file and you describe it in enough detail that somebody can reproduce it, so you have this disclosure that's enabling, it enables a person skilled in the art to reproduce it, then you won't get your invention. So be very careful about disclosures, where they are and how you make them. Another bar, this one's a little bit more of a tricky bar to sort of assess actually as a patent attorney or a patent professional than novelty, because the novelty you can say, right, somebody's made a new chemical reactor, here's some other chemical reactors that were made before, are they the same? Do they map onto each other identically? If they don't, they're not, then it's novel, it's new, even if it's got a slight difference that might not do too much, it's still new. But if the difference that makes it novel over what came before is kind of a routine or obvious, or it doesn't really change things, then what will happen is that people will say the invention is obvious and it's not inventive, and it doesn't meet the inventiveness requirement. So as I said there, something must not be an obvious development of the earlier technology in order to meet what's called inventive step. That's a very subjective question. It's actually very hard to assess, because everybody is creative, so it's very hard for us to sort of think, well, was that an obvious solution? Everything looks obvious in hindsight. So what the law does is it creates a person skilled in the art, which is this kind of legal fiction. It's a person who they say hasn't got a scintilla of creativity in them, but they can read books, they can sort of follow instructions, they can see what's in the lit and pick obvious pathways through it towards inventions. And if they would find it obvious to develop what come before into what you're trying to claim as your patentable invention, then it will get rejected for not being inventive enough. Novelty, inventive step, whether you've got an invention, are all very difficult questions to decide. And in fact, patent attorneys have to train for years and years to do these things. And it's still very difficult for us. So what can I do if I'm working in a field like chemical engineering, where I'm working with inventions and potentially patentable things, and I don't want to learn about the law? Well, hopefully these tips might help. So, as I've already said, inventions and patents that protect them can be very valuable. Millions, billions of dollars. They can literally be underpin an entire business, an entire company. So when in your day-to-day work, where you're solving problems all the time, technical problems, before you disclose it to somebody or publish it, before you give it to society, consider, was the problem you solved technical? If it was, then you might have made an invention, under my definition earlier on. Was the solution to that problem in the literature? Did you have to, could you just go away, find 3 articles and they all said, do this thing? Did you have a piece of apparatus and you were having, a problem with it, but, you could go away and look in a textbook and it says, do this? I mean, if the solution wasn't there, it wasn't that obvious clue, then you might have made something that's patentable because it might be new and it might meet that inventive step requirement that I mentioned. Would society find your solution valuable? So, if you sold, first of all, is what you've done, can it be made or used in industry? So will it meet the usefulness requirement? As I said, a low bar. But more importantly, if society would find it valuable, if I stopped competitors doing this thing, is there a commercial value to it? If so, then you should really be thinking about whether, as well as disclosing in a journal article or to your friends or to help people just generally, whether you should file a patent on it. Because if you've got an invention and you can patent it and be relatively sure that the money you spend filing the patent is kind of, it's not wasted, there will be a commercial value. You can license the patent, you can use it to stop other people from making your product or whatever, then file a patent on it. Think about that always in the back of your mind. The obvious flag is when you've got something that you want to disclose in a publication, because quite often you do get people very commonly draft a journal article, then go to a patent attorney the day before they're about to publish it and realize, oh, I could actually file a patent on this as well. So, you can have your cake and eat it if you like to do that. As I'm saying on the last bullet point on the slide. Another thing to remember when you're assessing what you've done to see if it's an invention, it's patentable, is it worth the time and effort and resource that it would be to get a patent, is don't assume that everything you've done is obvious. I think that's a problem I see a lot with inventors and people that work in your industry and the associated industries. Is you're all really clever people and you're all used to kind of solving things, and sometimes things that look like a very small simple problem, oh, I only did this, I only did that, they might be obvious to you, but they wouldn't necessarily be obvious to the skilled person. So that inventive construct I said that is used to assess whether something's patentable. So if they can't see the solution in black and white in a textbook, you're starting to think whether it would meet the patentability requirements for inventive step, and you might be able to get a patent. So if you're ever in a situation where you've done some of these bullet points, you think you might have a patentable invention, then it's always worth a chat with a patent attorney to see if there's some way you can commercially exploit your idea. I mentioned this very briefly. I've already said that public disclosures can prejudice novelty. So, but confidential disclosures do not. That might seem very obvious, but if you don't disclose to society, then society can't say you've already disclosed that you're not having a patent. So, so that's one reason to keep things confidential. You might be able to file it as a patent later on. The second important reason to keep things secret is that commercially valuable confidential information may be protected, even automatically protected, by trade secret laws, which, as I've already said, can be extremely valuable, some of the most valuable types of IP out there. So until you've decided whether you want to file a patent on something, keep it confidential until you've explored it with a patent attorney. If you then change your mind, or you think, okay, there is a filing here, you won't have fallen at the first hurdle by disclosing your own invention. So that's you might sound like that doesn't happen very often, but believe me, it happens quite regularly. Unfortunately, people sort of disclose it and then think, oh no, I wish I'd filed a patent, and by then it's too late. It's kind of a really fatal thing to do. If you think you've got something that's it's commercially valuable, so you meet that bar I said on the previous slide where it's society would find a use for it, but you don't think it's novel enough, or it's a bit obvious, maybe or the patent attorney says it's a bit obvious, you might get it, but it's going to cost you a lot of money to find out, then you might just keep it as a secret. Don't pay anything for it, keep it as a trade secret. It's still something that you can give to collaborators, and you can license out, sell it. It's got a value like the Coca-Cola recipe. So again, unless it's a value to disclosing something like the cachet or the sort of the heat that comes with the paper, then keep it secret and see where it gets you. And just as a general point, always you can keep confidentiality agreements, help people remember not to disclose things. So they're quite a weak protection in a way, because the bottom line is, even if someone breaches if you have an agreement to say, I'm going to tell you something, you've got to keep it a secret. If they breach it and disclose it, the damage is kind of done. You might be able to claim some damages back, but you might never be able to claim damage back for disclosing £1 billion patentable invention. So at the end of the day, the best way to keep things confidential is not to tell anyone. The second best way is to use confidentiality agreements. Make sure that you're telling people in confidence and that they understand that they can't just go out the next day and talk about another collaborator or another client or whatever about it. And there are various agreements you can use to do that. This link here is to a government website which just has a template you can use. Last couple of minutes on this whistle-stop tour, and I'm going to talk about patent ownership. Now, this is something that really fatally hamstrings a lot of patents, and it usually only hamstrings the most valuable ones, because it doesn't come to light until an invention is making so much money that people come out of the woodwork and say, I made that invention, or I contributed that invention, I'm not getting any money back for it. That's not fair. I'm going to sue you, because there are laws that say who owns an invention. They're trying to, again, make sure that people can't just run away with other people's invention. And the law says, in general, that the first owner of an invention and the patent that claims it will be the inventor. So the person that invents it. Good. That sounds right. That's fair. But if the inventor is an employee, and especially in our industries where your job as an employee is to make invention, it's to solve technical problems, then your employer will will own the inventions that you make as an employee for them. So that's the default that then it applies in most situations, to be honest, that come along. But then if it was a contract over that, that can modify that. So you can change it back to, the inventor owns it. It can change it to a different party owns it that's got nothing to do with the R&D process. All these kind of things can happen. And what happens often is that you can get patents and inventions that are owned by multiple people. And that's basically a nightmare. Because when you've got, if you have a car and you own it and you can do what you want with it, you can pick up who you want, you can go where you want. But if 4 people own your car and they all want to go and pick up somebody different, you get a bit of a nightmare. So how do you stop that happening? And it happens a lot. Well, what you do is, before you do some kind of collaborative project where there's a prospect of kind of multiple parties contributing and therefore kind of multiple inventors that each feed their rights to a different owner, whether it's themselves or their employer, or they're working under a contract that says it belongs to this person, you make sure that if you think something valuable is going to arise that somebody might want to exploit, that there's a contract that says, if it arises, this is who can use it, this is who can sell it, this is who can, gets their name on it, all those kind of things. So it might feel painful at the start, but it can sort of solve a lot of problems and save millions of pounds down the line. So please do consider doing that if you're going to do a collaboration. I think that's all I was going to have time for today. Sorry, I think it's probably taken a few minutes over, but I think we've definitely got time for questions if people haven't fallen asleep after that.
Thank you very much. Yes, does anyone have a question? I can check the chat. I do not see much. While everyone is looking, Nonny, what happens if you open a patent and you see it's complete blatant nonsense? You have something that makes absolutely no physical sense, but it's already granted patent, and you work in this area. What do you do with this?
That's a really good question, Nikolai, because that does happen quite a lot. I think people look at patents, either applications and granted patents, which are very different, and they look at it and think, oh, it covers me, I'm not going to bother with that piece of research. And actually, that's a very dangerous sort of conclusion to reach. And what you should probably always do, if you think your idea might be valuable, is before you throw it away and don't work on it, you should speak to a patent attorney, because first of all, people can't assert a patent application against you. So if somebody's filed a patent application, at some point it might get granted, but until it gets granted, they can't sue you. And a lot of patents never get granted for the reasons I've just said. They're not novel, they're not inventive, or they're not industrial applicable. So you must be careful not to think, oh, there's an application, it'll get granted, I won't be able to do it, I'll stop. First of all, check it's going to grant. Or, second of all, things do get granted that shouldn't have been granted. And that is where lawyers start to earn a lot of money, because what often happens is that your lawyer will say, okay, I've actually had a look at that patent and I've analysed it and I think it's weak, and actually think you could, there are mechanisms by which you can challenge patents. Again, if you think about it, the patent bargain, not good to have patents that stop people if they're not worth anything. So if something's worthless and it doesn't work and you think it won't work, you can challenge that patent in most systems and get it revoked. And if it's revoked, it will be as if it never existed. The problem is to sort of resolve that question of whether a patent was wrongly granted, or actually it doesn't cover you because they've captured it in a certain way and it protects this space, but we think we're outside it by a little bit. That costs a lot of money. But you should almost never just look at a patent and just give up hope. You should investigate it more. So that's a really good question. Yeah.
Thank you very much. Does anyone has a question? You are welcome to type it in or just ask directly.
Yes, and if there's anyone too shy, yes, I can see a question, but if anyone's too shy, you can always send it to my email address on the slides as well. I think there was a question there, Nicola, was there?
Yes, Natalia has a question. Natalia, do you want to ask it yourself, or you prefer me to read it?
I mean, I can read it if you like, just to make it a little bit easier for you, Natalia. Thank you, Natalia. That's a really good question. And again, it feeds back a little bit to my answer to Nikolai. You must be a bit careful. The patent system tries to do its best to make it clear to all the users of it, and the users of it include the people that own the patents, but also the competitors that want to work under the patents or around the patents, or in a similar area. It also tries to be fair to them. So one thing it tries to do is, where patents aren't in force, it tries to make it clear, and there are usually public registers that will tell you if a patent's abandoned. The problem with that is sometimes patents that are abandoned can be resurrected, and it isn't really that coherent how different countries, what abandoned means in a different country. So to give you an example that it's a little bit niche. Let's hope you never come to this problem. But if you abandon a patent in the UK, you abandon UK patents or a right issued by the UK government, in almost all cases that patent's dead, and it will show in the register as abandoned, and it's gone. You don't need to worry about it. In America, you can abandon a patent and then basically change your mind. So you can abandon it, it will say abandoned in the register, and you can then change your mind and pay the US government some money, and they'll say, oh no, don't worry about that, it's back. And that's actually a bit unfair. Actually, it doesn't happen in that many jurisdictions, but the US is a very important one. So the long answer to your question is yes. When something's abandoned, in practice, it can be exploited by others, but be a little bit careful. If you did practice it and they sued you and it would destroy your company, it would be worth paying a patent attorney or someone to make sure it's definitely dead. I can see a question from Janice there, I think. So I can just, so if someone else.
To answer the question directly so everyone can hear it.
Oh, sure, yeah. Yeah, sure. So the question is from Janice, and it's, if someone else would like to use a patented technology, does the patent holder have a complete freedom to choose a license fee? That's a really good question. That's the kind of good question where I'm a little bit behind the current law in this area. But I'm going to be honest about it and say I'm not sure. So yes and no. So I mean, the basic, again, what society's trying to do is, we've decided to use a kind of capitalist system that allows people to kind of get money for their things that have value and allows to trade those values, right? And it doesn't, generally speaking, capitalist societies don't like to sort of say there's a certain limit on what you can sell this for. They will say, I want the market to determine what it's worth, right? They want unseen forces or whatever to decide how much it's worth. So in theory, a patent holder can charge whatever they like for a patent. A sensible patent holder is only going to charge what the market will bear. But in most cases, they're not kind of obligated to, they don't have to, and I'm saying most cases here because there are some cases where they have to. But in most cases, they don't have to license if they don't want to. There are cases where societies come along and said, hang on a minute, there are some edge cases where that's really the thing that the patent system was designed to do, which is help society, is actually hindering us massively. And the two common ones, one is very close to home for me, and that's the compulsory licensing of pharmaceutical products. So there are usually in many countries, so one good example is India, which has a huge generic industry and a huge population with very difficult health challenges over it. And in India, they have license provisions that allow them to basically take a drug patent, for example, and if they really need it, the government can use it without paying. It's called compulsory licensing, or in return, sometimes in some of the systems, for kind of a nominal fair fee, which would obviously be nothing like the fair fee that the holder would like. So that's one example. Another one are things like FRAND things, or telecommunications. So you have things called standard essential patents, which, because the telecoms industry is kind of, it's a bit of a beast on its own. It's incredibly inventive, and it's had these kind of overlapping technologies. And when somebody comes along with a technology like, say, Bluetooth, that everyone wants to use, and if they don't use it, society is kind of artificially restricted, then you have these kind of laws in some kind of jurisdictions that allow sort of compulsory licensing or fair licensing of these kind of platform technologies that would otherwise just stop everyone working. So hopefully that answers your question, Janice. And then have we got time for one more, Nicola, or a few more? Okay, great. So I've got another question from Adam, which is, what is most economic, filing individual countries or for a world patent? So that's another really good question. I didn't really go on about the practicalities of patent filing, but they're very important. So first of all, there is no world patent as such. So you can't go to a patent office and file a patent that will cover all the countries of the world once it's granted. Once it's granted, there's no such thing as a world patent. There are some patents that you can file that when they're granted will cover multiple countries, like a European patent. So you can file a European patent that will cover the UK, France, Germany, Albania, if you want it. And there are patent applications that cover the whole world. So they're called PCT patents. You can file those and they cover, I think it's 157 countries or something like that. So you file one application, and then later on, after the application's been filed, you decide which individual countries you want to then enter from that sort of initial application. So it's not a world patent, but it's a world patent application. What is most economic? Depends. So I'm a lawyer, and nearly every answer I give you will be depends. So Nikolai's laughing because he knows how often I say depends, but it does depend. So if you are interested, I mean, if you are only interested in, you're only economically active in the UK, and you're only ever going to be a small entity, you know, you're not going to be multi-million, billion-pound entity. You're just happy having something to pass on as a family business. Then maybe you only need a UK patent for your invention. And the reason that you might only file a UK patent is something I didn't say is, you know, patents are very valuable, so they cost a lot of money. Patent attorneys have to train for years, cost a lot of money. Their lawyers cost a lot of money. Patent offices know how much patents are worth, so they make you pay as well. The governments will make you pay. So it costs a lot of money. A UK patent on its own doesn't cost much, but if you had to file in every country in the world, you'll be talking about multiple millions of pounds for the amount it would cost you over the patent's lifetime, I think. So it just depends. If you have an invention that is worth billions to the right company, but you're not that company, you're too small at the moment to do it, then maybe you would take a hit and spend more money on a world patent application like a PCT application, because that's going to be more attractive for a big company to buy, right? They might not come along and say, I don't want just a UK application. I sell in Europe, I sell in China, Japan. I need a PCT application at least so that I can buy all the protection I want in the different countries. So it depends, Adam. and the other answer I always give is talk to a patent attorney. So if you have a question like that, patent attorneys, you know, give free initial consultations and will help you with it. Yeah.
Thank you very much. I suppose we are spot on time. 40 minutes.
Oh, perfect.
I believe it's spot on time.
Close enough.
Yes, I do not know. May I just, if someone needs to leave, you're more than welcome. Just following up on the previous question, if you can possibly talk through major costs, and if you imagine yourself a sort of garage inventor who tries to come up with some idea, what's the best way forward? Or if you are in a major company, what's the best way forward?
Right, those are also good questions. So I think it is good to know the costs vaguely, because the first thing to say is that patents, you know, as a couple of my answers have kind of hinted at, that it's a pathway that you go on. You file an application, it gets examined to see if it's patentable, it may get granted. You might then file in different countries, and all along that timeline, costs are increasing, often exponentially. So when you file your first application, you pay one patent office. 12 months later, you generally do something which is called your file this with stand-to application, and you can file in every other patent office you want to file by referring to the first one you did. And obviously, you have to pay every patent office, so you've multiplied it, and then again, it gets even more expensive down the line. So it is expensive. The first cost you have to think about is whether you should pay a patent attorney to draft your patent. So, I mean, we didn't have time to talk about what a patent attorney is or does today, really, but we're kind of specialist lawyers who translate technical ideas into a legal document, a patent application. So you might come to me and say, I've improved this process for making a tablet. It's now much more robust, cheaper to operate. And I did these things. What do I do with that? How do I file a patent? So the patent attorney's job then is to take what you tell them in a technical sense and translate it into something that will protect in words what you're going to do, which is very difficult, and also get granted, so that you're not spending money on an application that's just it's not going to get granted, or it's going to be destroyed easily, or people are going to be able to get around it easily. So there's all that skill that goes behind it, is why we have to train for years and years, and we have yeah, I'm a sympathetic audience while moan about it, but they are some of the worst exams you can go. They're like actuarial exams, horrible things. But that means that they don't cost a lot. They're not cheap to get their services, and it does cost. Generally, I think the figure that our professional body uses is between £4,000 and £6,000 to have a patent attorney draft your application. So if you presented them with a journal article, say it might cost that much money just for them to draft the application. There might then be extra costs for them to file it and do all the steps down the line. You don't have to pay those costs sometimes, but I mean, obviously I'm going to advise you to do it, and the reason that you do that is if you make a mistake with a patent, it is very often fatal. Like, you can't come back from it, you can't amend it, you can't change the words you used, it's dead. So you really want to pay a patent attorney to make sure those problems don't come up. I mean, it's even hard for patent attorneys. So I mean, I've seen, since I moved out to a big company, I've seen multiple applications where the UK Patent Office, which by the way is a very nice public body, if you like work with governments and things and you think, oh, everybody's how horrible, the UK Patent Office, if you file an application that's so badly drafted they can tell it's not going to go anywhere, they'll refund all your money and they'll send you a nice letter and say, I can't work with this, go and speak to a patent attorney. So but they're really nice, because a lot of patent offices just take the money and say, no, you're dead and you can't fix it. But the UK Patent Office won't. So you have to decide whether to make that cost, £4,000 to £6,000. Then costs start to increase. So you may have to file it, and then obviously what happens then is a patent office looks at it and says, okay, you filed your application, is it patentable? Does it meet those criteria? Does it meet the patent bargain that I talked about, and should I give you a patent? So they will look at it and they might object to it and say, it's not novel, I found these other references and it's just an obvious development of these references, so it's obvious and you can't have a patent. Then you have to pay a patent attorney to argue for you and try and persuade them in law that they're wrong or whatever. So that costs money. Then your patent gets granted and you have to pay the patent office. That costs money. And then you have to maintain it. So for every year you maintain your right to exclude people, you pay the government of that country a fee. So the costs increase very roughly £4,000 to £6,000 to draft. Probably, by the time you get to foreign filing, which is where you decide you're actually going to go for it and file, start giving money to patent offices, you can be up to like 10 to 20 to 50,000, maybe even if you filed very broadly. And then over the lifetime of the patent, as I said, it can cost millions, depending on how many countries you go into. If you just have patents in the UK, the US, China, maybe 3 or 4 patents, it's going to cost 50k to 100k or something. But you can have patent families that cost millions. So yeah, it depends. And this is why, I mean, my firm does not advise people to file patents unless we think you'll get it granted, because it's already quite a big investment of time and money. So if you're an inventor, you've got something you've done yourself, to come to Nicola's other questions, you can phone up. There's a lot of patent attorney firms like mine or others in public directories and such like. And most of us are regulated, so we can't give you, we're bound to try and give you good faith advice and things like that. And we usually give free initial consultations. If you're working in industry, usually, you may have an in-house patent support. So you may have already heard your in-house attorneys give talks like the ones I've given. But if it never hurts to, if you think you've done something good and you're going to publish it, to go and talk to them and say, is there anything here? Can the company make a nice little earner on the side out of this? So yeah, again, if you don't, most companies will have some kind of IP rep or something you can talk to about that. Hopefully that answers that question.
Yeah, thank you very much. Thanks a lot for everyone for attending. We will keep this recording available. Yes, and let's hope to see you next time. Thanks a lot. Thank you, Nonny.
Thank you everyone for listening. Have a nice day. Thank you.